Hello dear friends, today we are going to continue chapter 2 from page 47. General principles regarding allotment. Allotment of shares means the act of appropriation by the board of directors of the company out of the previously unappropriated capital of a company of a certain number of shares to persons who have made applications for shares. In reply to Calcutta Stock Exchange Association, it was held so. It is on allotment that shares come into existence. The following general principles should be observed with regard to allotment of securities. 1. The allotment should be made by proper authority. The proper authority may be the board of directors of the company or a committee authorized to allot securities on behalf of the board. 2. Allotment of securities must be made within a reasonable time. As per Section 6 of the Indian Contract Act 1872, an offer must be accepted within a reasonable time. What is reasonable time is a question of fact in each case. An applicant may refuse to take securities if the allotment is made after a long time. As per Section 56, within a period of 2 months from the date of allotment is the case of allotment of any of its shares. 3. The allotment should be absolute and unconditional. Securities must be allotted on same terms on which they were applied for and as they are stated in the application for securities. Allotment of securities subject to certain conditions is also not valid. Similarly, if the number of securities allotted is less than those applied for, it cannot be termed as absolute allotment. 4. The allotment must be communicated. As mentioned earlier, posting of letter of allotment or allotment advice will be taken as a valid communication even if the letter is lost in transit. 5. Allotment against application only. Clause 55 of Section 2 of the Act requires that a person should agree in writing to become a member. And 6. Allotment not to be in contravention of any other law. If securities are allotted on an application of a minor, the allotment will be void. Case laws. Judicial pronouncement relating to allotment. An allotment may be valid even if some defect was there in the appointment of directors but which was subsequently discovered. That is Section 299 and the rule in Royal British Bank versus Tarquin. Second case, an allotment by a board irregularly constituted may be subsequently ratified by a regular board. In Portuguese Consolidated Copper Mines case. The third case, a director who has joined in an allotment to himself will be stopped from alleging the invalidity of the allotment. The fourth one, Grant applied for certain shares in a company. The company dispatched letter of allotment to him which never reached him. It was held that he was liable for the balance amount due on the shares. In Household Fire and Carriage Accident Insurance Company Limited versus Grant. And the last one, there can be no proper allotment of shares unless the applicant has been informed of the allotment. British and American Steam Navigation Company. The next topic is share certificate. What is a share certificate? A share certificate is a certificate issued to the members by the company specifying the number of shares held by him and the amount paid on each share. According to Section 45 of the Companies Act 2013, each share of the share capital of the company shall be distinguished with a distinct number for its individual identification. However, such distinction shall not be required as per proviso to Section 45 if the shares are held by a person whose name is entered as holder of beneficial interest in such shares in the records of a depository. In terms of subsection 1 of section 46 of the Act, a certificate under the common seal, if any, of the company or signed by two directors or by a director and the company secretary wherever the company has appointed a company secretary is prima facie evidence of the title of the person to the shares specified therein. The certificate is only documentary evidence of title in the possession of the shareholder, but it is not a warranty of title by the company using it. When can a company issue duplicate share certificate? Subsection 2 of section 46 states that a duplicate certificate of shares may be issued if such certificate A is proved to have been lost or destroyed, or B has been defaced, mutilated or torn and is surrendered to the company. Manner of issuing share certificate or duplicate share certificates. Subsection 3 of section 46 states that notwithstanding anything contained in the articles of a company, the manner of issue of a certificate of shares or the duplicate thereof, the form of such certificate, the particulars to be entered in the register of members and other matters shall be such as may be prescribed. Below is a diagram that is given. It is said that share certificates under Rule 5 of the Company Share Capital and Debenture Rules 2014 deals with issue of share certificate, and Rule 6 of the Company Share Capital and Debenture Rules 2014 deals with issue of renewed or duplicate share certificate. Next is a table that is given. It is describing issue of share certificate and issue of renewed or duplicate share certificate. So I'll be reading all the points of issue of share certificate and then I'll be going to the points of issue of renewed or duplicate share certificate. Issue of share certificate. Board resolution be passed and letter of allotment or fractional coupons of requisite value must be surrendered to the company. In case the letter of allotment is lost or destroyed, the board may impose reasonable terms. Certificate shall be issued in the form number SH1 and shall specify the name of person in whose favor the certificate is issued, shares to which it relates and the amount paid up thereon. Every certificate shall specify the shares to which it relates and the amount paid up thereon and shall be signed by two directors or by a director and the CS wherever the company has appointed CS. In case the company has a common seal, it shall be affixed in the presence of persons required to sign the certificate. In case of an one-person company, it shall be sufficient if the certificate is signed by a director and the CS or any other person authorized by the board for the purpose. A director or company secretary shall be deemed to have signed the share certificate if his signature is printed thereon as facsimile signature by means of any machine, equipment or other mechanical means such as engraving in metal or lithography or digitally signed, but not by means of rubber stamp, provided that the director or company secretary shall be personally responsible for permitting the affixation of his signature, thus and the safe custody of any machine, equipment or other material used for the purpose. Particulars of share certificates to be entered in the register of members. And with that we come to the end of the points that are written under issue of share certificate. Now let us come to issue of renewed or duplicate share certificate. Renewal to be made only on surrender of old certificate. Company may charge fee for duplicate share certificate as the board decides but not exceeding 50 rupees per certificate. Company shall not issue any duplicate share certificate in lieu of those lost or destroyed without the prior consent of board. If the company is listed, then the duplicate share certificate shall be issued within 45 days, and if the company is unlisted, it shall issue the certificates within 3 months from the date of submission of complete documents with the company. The particulars of renewed and duplicate share certificates to be entered in the register of renewed and duplicate share certificates maintained in form number SH2. The register shall be kept at the registered office of the company or at such other place where the register of members is kept and shall be preserved permanently and shall be kept in the custody of the company secretary of the company or any other person authorized by the board for the purpose. On fraudulent issue, the company shall be punishable with fine, which shall not be less than 5 times the face value of shares involved, which may extend to 10 times or rupees 10 crores, whichever is higher. Officer in default shall be liable under Section 447. Maintenance of share certificate forms and related books and documents. Rule 7 of Companies Share Capital and Debenture Rules 2014. Point number 1. All blank forms to be used for issue of share certificates shall be printed and the printing shall be done only on the authority of a resolution of the board, and the blank form shall be consecutively machine numbered, and the forms and the blocks, engravings, facsimiles and hues relating to the printing of such forms shall be kept in the custody of the secretary or such other person as the board may authorize for the purpose, and the company secretary or other person aforesaid shall be responsible for rendering an account of these forms to the board. Point 2. The following persons shall be responsible for the maintenance, preservation and safe custody of all books and documents relating to the issue of share certificates, including the blank forms of share certificates referred above, namely A. The committee of the board, if so authorized by the board, or where the company has a company secretary, the company secretary, or B. Where the company has no company secretary, a director specifically authorized by the board for such purpose. And point 3. All books mentioned above shall be preserved in good order, not less than 30 years, and in case of disputed cases shall be preserved permanently. And all certificates surrendered to a company shall immediately be defaced by stamping or printing the word cancelled in bold letters and may be destroyed after the expiry of 3 years from the date on which they are surrendered under the authority of a resolution of the board and in the presence of a person duly appointed by the board in this behalf. The above mentioned provisions shall not apply to cancellation of the certificates of securities under subsection 2 of section 6 of the Depositories Act 1996 when such certificates are cancelled in accordance SEBI Depositories and Participants Regulations 1996 or 2018 as the case may be. Record of depository is prima facie evidence for shares in depository form. Subsection 4 of section 46 states that where a share is held in depository form, the record of the depository is the prima facie evidence of the interest of the beneficial owner. Issuing duplicate share certificates to defraud. According to subsection 5 of section 46, if a company with an intention to defraud issues a duplicate certificate of shares, the company shall be punishable with fine, which shall not be less than 5 times the face value of the shares involved in the issue of the duplicate certificate, but which may extend to 10 times the face value of such shares or rupees 10 crores, whichever is higher, and every officer of the company who is in default shall be liable for action under section 447 for fraud. Time of issue of certificates of securities. Under subsection 4 of section 56 of the Act, every company, unless prohibited by any provisions of law or any order of any court, tribunal or other authority, must deliver the certificates of all securities allotted, transferred or transmitted A. Within a period of 2 months from the date of incorporation in the case of subscribers to the memorandum. B. Within a period of 2 months from the date of allotment in the case of any allotment of any of its shares. C. Within a period of 1 month from the date of receipt by the company of the instrument of transfer or, as the case may be, of the intimation of transmission in the case of transfer or transmission of securities, and D. Within a period of 6 months from the date of allotment in the case of any allotment of debenture. However, where the securities are dealt within a depository, the company shall intimate the details of allotment of securities to depository immediately on allotment of such securities. Proviso to subsection 4 of section 56. Where any default is made in complying with the above provisions, the company shall be punishable with fine, which shall not be less than 25,000 rupees, but which may extend to 5 lakh rupees, and every officer of the company who is in default shall be punishable with fine, which shall not be less than 10,000 rupees, but which may extend to 1 lakh rupees. This is mentioned under subsection 6 of section 56. In case of specified IFSC public company or specified IFSC private company, it shall deliver the certificates of all securities to subscribers after incorporation, allotment, transfer or transmission within a period of 60 days. This is the notification dated 4th January 2017. Significance of share certificate. A certificate of shares is evidence to the effect that the allottee is holding certain number of shares of the company, showing their nominal and paid up value and distinctive numbers. This certificate is a prima facie evidence of title to the shares in the possession of shareholders. This is mentioned in Societe Generale de Paris versus Walker. Moreover, when the company issues a certificate, it holds that the facts contained therein are true. Any person acting on the faith of the share certificate of the company can compel the company to pay compensation for any damage caused by reason of any misstatement in the share certificate, as the company is bound by any statements made in the certificate. Share certificate is the only documentary evidence of title, and that the share certificate is a declaration by the company that the company in whose name the certificate is issued is a shareholder in the company. A case is given in the parenthesis, Ghanshyam Chaturbai versus Industrial Ceramics Private Limited. Also, the company cannot dispute the amount mentioned on the certificate as already paid. Another case, Blumenthal versus Ford, 1897. The next topic is damages against company and directors for wrong certificates. As already mentioned, a person acting on the share certificate issued by the company may recover compensation for the damages suffered by him. The measure of damage is the value of the shares at the time of the refusal by the company to recognize him as a shareholder, together with interest from the date. Example of a case law, Behla and San Francisco Railway Company. Where directors issue a certificate of title of shares which the company has no power to issue, they may be held personally liable to damages on an implied warranty of authority to any person who acts on such certificate. Split certificate. A split certificate means a separate certificate claimed by a shareholder for a portion of his holding. The advantages of a split certificate are that the shareholder may benefit in case of a transfer by way of sale or mortgage in small lots, and the right to multiply the certificates into as many shares held by the shareholder. Purpose and form of share certificate. With the help of a share certificate, a member of a company may deal with his shares in the market, whether it is one of sale, mortgage or pledge, by showing a good prima facie marketable title to the shares. A share certificate is a documentary evidence of title to shares in the possession of the shareholder. It is a prima facie evidence of his title to the shares. Subsection 4 of section 46 provides that where a share is held in a depository form, the record of the depository is the prima facie evidence of the interest of the beneficial owner. Let us remember, every share certificate or every certificate of share or shares shall be in form number SH1 or as near thereto as possible. The particulars of every share certificate issued shall be entered forthwith in a register of renewed and duplicate share certificates maintained in form number SH2. Whether share certificate on official publication. The question whether a share certificate is an official publication within the meaning of Clause C, subsection 3 of Section 12 was considered by the Department of Company Affairs, now Ministry of Corporate Affairs, and the department has clarified White Circular number 3/73 dated 3/2/1973 as follows. It will be seen that in terms of Section 44 of the Companies Act 2013, the shares in a company are movable property transferable in the manner provided in the articles of the company. Section 46 of the Companies Act 2013 provides that a certificate under the common seal of the company specifying any shares held by any member shall be prima facie evidence of the title of the member to such share. With the Companies Amendment Act 2015 coming into force, the common seal is no more mandatory. The implications and signatories have been discussed earlier. Thus, shares are movable property transferable in the manner provided in the articles of the company, and that the share certificates are certificates of title and are movable property but are not publications in the nature of prospectus, balance sheet, profit and loss account, and notice or advertisement. The conclusion reached, therefore, is that the share certificate is not an official publication within the meaning of Clause C, subsection 3 of Section 12 of Companies Act 2013. Legal effect of share certificate. We have already stated that a share certificate is prima facie evidence to the title of the person whose name is entered on it. It means that the share certificate is a statement by the company that the moment when it was issued, the person named in it was the legal owner of the shares specified in it, and those shares are paid up to extent stated. It does not constitute title, but it is merely evidence of title. It is, however, a statement of considerable importance. For it is made with the knowledge that the persons may act upon it in the belief that it is true, and this facts brings into operation the doctrine of estoppel. As a result, a share certificate once issued by the company binds it in two ways, namely A, by estoppel as to title, and B, by estoppel as to payment. Estoppel as to title. A share certificate once issued binds the company in two ways. In the first place, it is a declaration by the company to the entire world that the company in whose name the certificate is made out and to whom it is given is a shareholder in the company. In other words, the company is estopped from denying his title to the shares. Next is estoppel as to payment. If the certificate states that on each of the shares full amount has been paid, the company is estopped as against a bona fide purchaser of the shares from alleging that they are not fully paid. If a person knows that the statements in a certificate are not true, he cannot claim an estoppel against the company, barrow case. Despite everything, a certificate must be issued by someone who has the authority. For example, where the secretary forged the signature of two directors in a company, the company had refused to register the holder of shares as a member. Further, a certificate is not an evidence as to the equitable interest in shares. Also, where an individual is aware of the false statements in a certificate, he will not be entitled to claim an estoppel. Personation of shareholders, Section 57. Where any person deceitfully personates as an owner of any security or interest in a company, or of any share warrant or coupon issued in pursuance of this act, and thereby obtains or attempts to obtain any such security or interest or any such share warrant or coupon, or receives or attempt to receive any money due to any such owner, he shall be punishable with imprisonment for a term which shall not be less than 1 year, but which may extend to 3 years, and with fine which shall not be less than 1 lakh rupees, but which may extend to 5 lakh rupees. To personate means to pretend to be someone else, especially for fraudulent purpose such as casting a vote in another person's name. Personation and impersonation imply the same thing. With this, we come to the end of Part B of Chapter 2, that is page 53. In the next audiobook, we'll be starting from page 54, that is Part C, Issue of Securities.